this video, attorney, I'm gonna discuss the section 38 to 42 of the Republic Act number 11479, also known as the Anti-Terrorism Act of 2020. The section 38, it states safe harbor. The definition of it is a safe harbor is a legal provision in a statute or regulation that provides protection from a legal liability or other penalty when certain conditions are met. So, for example, of the safe harbor, attorney, is when use avert the hostile to take over. The safe harbor is regarded as a short repellent that will make a company avoid being forcefully acquired by the another company. Example of another safe harbor is used to avert the hostile takeover are golden parachutes, poison pills, scorch herb policies, and other things. And one thing fact about safe harbor, it protects us from a safe harbor. It is a law that protect people and businesses from being responsible for unforeseen mistakes. These laws give peace of mind of anyone acting in good faith who may otherwise be violating the law for reasons out of their control. So that's my explanation about the section 38, safe harbor. In section 39, is the bank official and employees defying a court authorization. It states that, that's the title, and then my definition to it, or how I explain it. It is an employee or any employee, official, or member of the board of directors of the bank. Uh, I'm sorry. Or the financial institution who refuses to allow the examination of the deposits, placements, trust accounts, assets, and records of a person charged with or suspected of the crime or of terrorism or the crime of conspiracy to commit terrorism. It is a judicially declared and outlawed terrorism organization, which is uh, uh, which is it is a group of person, any group of person inside bank or financial institution, and might happen in here is that when duly served, with a written order of the authorizing division of the Court of Appeals, he shall be guilty of an offense and shall suffer the penalty of 10 years and 1 day to 12 years of imprisonment. So, kung sa Bisaya pa, wala ipili kutob sa mga trabaho sa bangko. If naigpadang suwat gikan sa gikan sa korte, then ilara baliwalaon, still makakuan sila. Held as they will receive a penalty. So anyway, in section 40, it states that the immunity and protection of government witnesses. So, in the definition of this, it is witnesses compelled by Sophonia to appear before a grand jury are entitled to receive immunity in exchange for testimony. The grant of the immunity impairs with the witness right to invoke the Fifth Amendment protection against self-incrimination as a legal basis for refusing to testify. So if we wonder what does immunity mean for a witness, it is a use and derivative. Use immunity to protect the witness from having the prosecution, so that they can use their statements or any evidence discovered from the statements against them. Essentially, this produce the same result. No? As the witness invoked their Fifth Amendment privilege and did not testify at all. So immunity meaning in the government, by simple term, is that exemption from penalties, payments, or legal requirements. granted by authorities or statutes. And I also discovered that the main types of the immunity are witness immunity, public officials immunity from liability, then sovereign immunity, kanang mga diplomatic immunity. Those are the factors considered when granting immunity from prosecution witness. From prosecution for witness include the seriousness of the offense, reliability, and involvement. In criminal activity. That's how the section 40 works. So in the section 41, it states the penalty for unauthorized revelation of classified materials. So, in my observation, in my own explanation, in how I define it, it states the penalty for an unauthorized revelation of classified materials. And this means that shall be fined under this title or imprisoned not more than 10 years or both. So penalties for violating this statute can include fines, imprisonment, or both. It is important to know that the mishandling classified documents is not only a criminal offense, but also a violation of national security. That's how it works at the section 41. And at the section 42, it states right here. And at the section 42, it states infidelity in the custody of detained persons. It states right here that any public officer who was direct custody of a detained person under the provision of this act and who by his deliberate act, misconduct, or inexcusable negligence causes or allows the escape of such detained person shall be guilty of an offense and shall suffer the penalty of 10 years of imprisonment. So, para nako kay infidelity in the custody of detained persons manisiya. So, the crime of infidelity in the custody of prisoners can be committed only by the custodian of a prisoner. Example, a policeman escorted a prisoner to court. Kana, muna example at the section 42. And that's all about my report, attorney, from section 38 to 42. Thank you, attorney, so much.